I was more call about over daily update TV. So then I will show you made in and not subscribe and not share out the comments and social conversation. A budget brain I can make phone and phone you know. We a Zoom interview where the Justice William Atuguba was settle everything was settle bibia ami home baby no crane down. I say a same way na abano. Precedent we no it will affect the near future. It will affect us in the near future. One, I say asem we nya asem a we say Supreme Court so. Enya asem a we say Supreme Court entertaining afenyo markets and those applications not the buying. Or say enke we say asem High Court and the mandate to talk about this. And like I said, the justice or the Chief Justice, this is application of common sense. Common sense must be applied. There is a papa ni buwa fupa. Or should I say, ruling nearby, there should be application of common sense to it. I was saying now we use common sense. I was saying Torkono or the judges that sat on the case, I was saying we use common sense. And like I said, assembly I was saying Supreme Court, a High Court assembly. And I'm saying the Supreme Court is politically affiliated, no. And no na emo mo yede e tena assembly so nka assembly de e clear. E obvious. I deal up the TV so. Eti Atuguba amekini clear say assembly omonde call Supreme Court totally a violation cry because I was a High Court and a tennis assembly. Or say High Court and a disassembly. Or say High Court and a cast assembly added year 2 year and the Supreme Court. Oh, nani buo for ye pa. Yonko he a full interview. Ewa interview wa kansem woman. Abusia. And the man is a man of law. He has been a Chief Justice, but ain't only Mrano. Abusia, you go to a full interview. We share you money, now I share, now I like it. God bless you.
And the interpretation of Article 97, 1G and H became a bone of contention. The High Court, by Article 130, was required to stay proceedings and refer the issue to the Supreme Court. But in the contention of Justice Amadou Tanko, this procedure is not that which was employed in this case. And as a result of sidestepping this procedure of this High Court's jurisdiction being invoked on this case, but rather going directly to the Supreme Court, it negates the Supreme Court's jurisdiction on this particular case. I want to find out your thoughts on this matter of jurisdiction, whether it has been settled, really, by the recent ruling.
Thank you. This question of jurisdiction ought to have been regarded as settled long ago if the court was minded to follow precedent. Well, the court is bound by its previous decisions. It can depart from them for good reason. But there came a time this provision about stare decisis has virtually been negated. You'll find in the latter days, and take it from, let's say, 2012, thereabouts going, you find there's complete and frequent violation of that rule of stare decisis. The question about the jurisdiction in this matter, I mean, could not have been a serious problem. if these stare decisis were observed. First of all, even let's ask a very common sense question. When parliamentary results are declared and people are contending that they rather should have been elected, the results were not fair, where do they go? Is it not to the High Court? And who has ever said that that's the wrong forum? Common sense. And this common sense is supported by the provisions of the Constitution. Otherwise, how could it have been happening? Unchallenged. But suddenly, beginning from, I think, the Beer case, second day, Amado and Beer versus second. No, he rather even went a second day. Here was a case that concerned the validity of the election of the MP for Boku Central, I think. The challenge to his election went to the High Court, and it was thrown out while it was out of time. They went to the Court of Appeal, they failed there, and then a new action was brought to the Supreme Court. This same situation arose, I think, in 1997 or so, in the case of Yeboah versus J.H. Mensah. I was on that panel. Let's briefly state the facts. J.H. Mensah, I think it was from Sunyani or so. He didn't contest that particular election from where he hailed from. That's Sunyani. He went to another place, and he did not reside there for a continuous period or an aggregate of 5 years, as required by the Constitution. And actually, if the plaintiffs had taken that matter up in the High Court within the 21 days, he would have been thrown out of Parliament. Because he clearly was satisfied. But they waited until that period had expired. And now, and that's where I want always to be forthright. This man turned out to be a problem to the government of the day in Parliament as minority leader. And I think some felt that should be a way to get him out. They then found that the High Court gate was closed, so they sought to circumvent that by coming to the Supreme Court. I was on the panel. And the issue. Now, interestingly enough, it was this our same president who was counsel for J.H. Mensah. And he contended that the Supreme Court had no jurisdiction. It was a parliamentary matter. Now, we're confronted with the previous decision of Weduma versus Awana Williams. That was decided in 1969 by judges one dares not to disagree with. But that is beside the point. When this matter came before me, I must confess, I was suspicious. Why is it that after all this time they are coming with this matter? Is it because the man is a pain in somebody's flesh? So I said to myself, if I look at this matter and I find that you know, there's no jurisdiction, I'll throw the case out. That was my approach. So I read that Wedima versus Awan Williams.
Yes.
And Azu Crab, who read the judgment, who wrote it, said that on the issue of parliamentary election, the Supreme Court and the High Court had concurrent jurisdiction. So I had to consider this one over and over and over as a pure legal question, not question of politics as we are doing today. And I found that notwithstanding their distinguished judicial status, I couldn't agree with them that when the Constitution says in Article 130 that subject to the High Court jurisdiction of fundamental human rights, the Supreme Court shall have exclusive jurisdiction with regard to interpretation and enforcement. It can at the same time, how can something be exclusive and be concurrent at the same time? So when I got to that idea, I said, no, I will not accept their reason. And that found me to rule in favor of J.H. Mensah. We're 5 on the panel, only 1 dissented. We took time, wrote lengthy judgment and analyzed. When BLBL case came, the lead judgment didn't, as far as I can recall, didn't deal with that, didn't try to see whether we're right in departing from Williams and Wedima. Nothing. Just said that, each time that the person continued to sit in the Supreme Court, in the Parliament, was a new course of action. Now, I don't see this in it, because there's one provision governing the status of the elected person. And in my opinion, that makes it an action in rem. It relates to the status of the elected person, and an action in so that accrual of course of action keeps on. And even if it is, the express limitation period is there. So, we departed from our Williams and clearly established that in matters of parliamentary tenure, election, validity of elections, and so forth, the High Court is the proper forum.
The High Court is the proper forum?
Yes. For the determination of the validity of a parliamentary election. And of course, by extension, that's just one item of that jurisdiction. If there are others, also like vacation, it simply follows common sense, common logic, that the same thing will apply.
So in that sense, the Supreme Court shouldn't have even entertained this particular case at all?
At all. Now let me emphasize. A jurisdiction to interpret and to enforce under Article 130 is described as an original jurisdiction. I'm saying that in a situation like this, they don't have original jurisdiction. What they have is a jurisdiction of reference. The subject matter belongs to the High Court. And the same Article 132 makes it clear that in a situation like that, they have only reference jurisdiction. So I don't see, I don't know. That's why I'm emphasizing. And I think that at the heart of all this pretentious discussion going on, there's no true legality involved. It's just politics, that honorable type. all we are doing is the paramountcy of political partisanship. Partisanship. That is what is controlling this country. If that is not addressed, we are just wasting our time. True law no longer will apply, where the basis of anything in this country is politically driven. That is the menace. I agree with Martin Pebbles' observations along these lines. That is a fundamental matter. Unless it's arrested, this menace, this vice will continue to fester, and constitutionalism will be subverted. Paid lip service to people's suffer. In other words, we are not entitled to benefit from the constitutional order put in place for this country. That is the true situation. That's the true evil to be addressed.
So, when you make reference to the fact that clearly the Supreme Court shouldn't have entertained this case at all, in the recent ruling of the 5 who ruled in favor of the plaintiff, they argue that although the High Court had jurisdiction with regard to whether a seat is vacant or not in Parliament, what was before them was purely a question of law regarding the true interpretation of 97(1) and H, and not factual disputes regarding seat vacation in Parliament.
Sorry to say, that's superficial reasoning.
That's superficial reasoning.
Yes. It is not, but that issue has been addressed by Article 132. Now, where it arises in a matter belonging to another court, the Supreme Court only comes in when an interpretation or enforcement issue arises and is referred to the Supreme Court. That is the only time they can come in. So you don't, take 132 about is it not dealing specifically with that question of law that they are talking of and how it should be, brought to the Supreme Court?
Indeed, 132 says where an issue that relates to a matter or question referred to in Clause 1 of this article arises in any proceedings in the court other than the Supreme Court, the court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
Yes, that is the constitutional order. And let me say this, those days that law was, there was fidelity to the law, and even today is reflected in their judgment, the majority judgment. Jurisdiction is a fundamental matter. So the conditions upon which your jurisdiction arises, if they are not there, you don't have the jurisdiction. And that is it. Now this matter is directed to the High Court. However patent the constitutional issue that may arise there, you don't have original jurisdiction, you have jurisdiction of reference. That is it. Is that what they exercised? That's not what they exercised. They purported to exercise original jurisdiction, whereas in this kind of situation, it is only reference jurisdiction. It's quite clear from the same provisions of 130.
So as the Supreme Court has always held consistently, a point of jurisdiction, when taken and successfully upheld, should foreclose any consideration of the merits of any case.
Completely. You don't have jurisdiction, how do you touch the merits? And even in the majority, there is clearly and plenarily stated therein, and I agree with that. Even there's saying as is solidly laid down, that as for jurisdiction is so fundamental that even if the parties don't raise it, the court itself, suo motu, ex debito justitia.
So sounds like there will be no foundation upon which the merits can stand.
At all. How can you put something of Mafua and USC? Mosi and Bajina? Mafua and USC, I think it's something, but as for Mosi and Bajina, I think it's 1963, volume 1, Ghana Law Report, page 634 or so. Supreme Court. Atuguba ASC wrote that unanimous judgment. So, I mean, you don't say that the same issue would have come. The thing is, when do you have jurisdiction over the issue in a matter that is consigned to a lower court? That is it. No, you don't substitute desiderata for, actuality of jurisdiction. Supreme Court.
Well, Justice, I want to make the point and say that to the extent that this matter of the High Court incidental to the majority decision will be reversed. You agree with that?
Well, yes, but the thing is, as I've told you, in the course of time, the Supreme Court was not faithful to the constitutional prescription of stare decisis. So you find Biabel and second day going off tangent, entertaining a matter that should have been commenced in the High Court, and then some followed. It's very interesting. If you read that Biabel case, look, the Doce and another justice, that's interesting, eh? They disagreed with the majority decision on the grounds that I'm canvassing. The same grounds. That's very interesting. I think when in human life, it's important to apply realism rather than add things. That's very significant that happened. The majority decision didn't even discuss, if I remember well. I'm yet to go back to my books. It's 6 years since I've retired, but I think I'm recollecting.
Indeed.
They did not examine Awana Williams and Gredima. They did not examine Yeboah and Mensah and so forth, and try to demonstrate why those decisions should not bind them. That is, from a certain time, the Supreme Court, after that, you started sliding down judicial. I'm telling you. You find that this stare decisis was not observed. You find a panel taking a decision one way, then another case comes. Either the same panel or a good number of those who decided would take a contrary stand and then back and, this wasn't happening before. That's why I'm saying something fundamentally has gone wrong. That is what has to be redressed. If we are to get back on track and run this country properly and not politically and myopically. Now,
sir, and you think that politics is a cause of this, that the judiciary continuously been drawn into politics? Because that was a concern by many that this case may have just overly exposed the judiciary to the politics of it, sir.
Yes, you said?
Sorry, I lost you briefly then. You are talking about the problem that we have, the problem that we are faced with now. And yes, the concern that was raised when this matter started was that this was going to open up the judiciary for the politics of this particular issue. And do you see that as a problem here?
It's a problem. That's the realistic problem. Now I'll demonstrate it. Look even at the empanelment. People has referred to all those. I mean, for what reason will you bring the younger justices to handle such a weighty matter to the exclusion of the seniors? What reason? I mean, this reason, sir. Then they brought in these two others, but I mean, what were they going to do? In fact, even legally, I don't see whatever was left for them to decide on the substance, because in rejecting the application to set aside their injunction or their directive, they had ruled that they had jurisdiction. They had already decided that they had jurisdiction. The speaker had no jurisdiction over the matter. It was so what